Well, as generations of Federalist Society chapter presidents will testify, I never agree to debate. I don't like the debate format because I believe it rhetorically commits you to beating the other side or to have the other side beat you. You have to win. And as a former prosecutor, I sort of feel like if I had still wanted to be engaged in that kind of activity, I would have stayed a prosecutor and stayed in the criminal justice system. There's only one time I made an exception for this. About 15 years ago, I think it was, I agreed to debate Professor Carl Bogus, on the meaning of the Second Amendment. And I don't exactly know why I made an exception in that case, except maybe it was just way too tempting to debate somebody whose very name was bogus. I mean, I just think that was just too big a temptation to pass up. So why did I make an exception in this case? I'm still not exactly sure why, except it's probably the opposite reason, and that is I have such a high regard for both the intelligence and reasonableness of my debate opponent here, and also I think really more importantly, we're both working within the same paradigm and trying to work out in good faith the meaning of the paradigm that we both share basic principles in. This is not a situation in which one person's sort of pretending to be inside the tent. We're both inside the same tent, just trying to figure out where that tent really is. And so it's a useful enterprise, and I think it'll be profitable to you, and it's been profitable to me. So let me begin my remarks by defining what I mean by interpretation and what I mean by construction. Both interpretation and construction are activities. Interpretation is the activity of identifying the semantic meaning of a particular use of language in context. Construction concerns the application of that meaning to particular factual circumstances. Now, originalists may disagree about many things, including how we should do interpretation and maybe especially how we should do construction. But we should all agree on the meaningfulness of this distinction, the distinction between interpretation and construction, which is really the topic of this disagreement, this debate. For without it, I believe, we are very likely to be talking past one another or our critics and confusing ourselves and confusing others. So let me just begin, now let me say that first and foremost, all originalists believe that the semantic meaning of the Constitution is fixed at the time of its enactment. And assuming the Constitution is legitimate, let me just say something about that assumption, which always has to be inserted here. It is an assumption. It is an assumption that's got to be made, and it's an assumption, the proof of which, or the convincing of which, is outside the Constitution, so that the Constitution doesn't establish its own legitimacy. There you need an exterior theory or notion about what makes the Constitution legitimate, and we could very well disagree about what that theory is while still agreeing that if the Constitution is legitimate, it should be followed by those who are governed by the Constitution, in particular by those members of the government who take an oath to uphold it. The Constitution is the law that governs them and cannot be changed by them without going through the amendment process. Now, where the semantic meaning of the text provides enough information to resolve a particular issue, and notice I'm not saying case and controversy, because this could apply, for example, in the legislative branch, and not necessarily in the judicial branch. I'm just using the word issue here. Where the semantic meaning of the text provides enough information to resolve a particular issue, then in application, it will require little, if any, supplementation, and construction will look indistinguishable in practice from interpretation. The application will look like a straightforward reading off of the text. But however much information is contained in the text of the Constitution, there is not always enough information to resolve a particular issue. Now, to see why this is so, it is crucial to understand how language can be either ambiguous or vague. Consider the example of a light feather, or a feather that is said to be light. The term light can be both ambiguous and vague. A feather could be said to be light in two different senses, and therefore ambiguous. Light could refer either to the weight of the feather or to its color or shading. When I say that that feather is light, most likely I mean one of these senses or the other, but I don't usually mean both at the same time. And the context usually reveals which of the two senses I mean. The term arms in the Second Amendment, for example, could be referring to weapons, or it could be referring to the limbs to which our hands are attached. Context reveals it to be referring to weapons. But even where context reveals which sense of light or arms is the intended meaning, there is still a problem of vagueness. Just how heavy must an object be before we cease calling it light and start calling it heavy? How tall must a person be before he is no longer short? Is any weapon included in the meaning of arms in the Second Amendment? Nuclear weapons or weapons in common use by ordinary citizens? What's exactly in and what's exactly out? Now, the problem of ambiguity, I think, must be distinguished from the problem of vagueness, because ambiguity can usually, though not always, be resolved by what Mike and John call interpretive methods. And by John, I mean John McGinnis, Mike's co-author, in his piece in the Northwestern Law Review, in which he greatly expands upon the position he just identified here in his presentation, Mike's presentation. So we might adopt in interpretation the procedure of accepting the most probable meaning based on the available evidence, which is what they recommend, and I think which is what we all do. Now, I should note, however, just in passing, that there's a special problem of ambiguity can arise either when evidence of meaning is lost or non-existent, in which case we have an epistemic problem, or when the drafters deliberately injected ambiguity into the text on purpose by using, for example, euphemisms whose public meaning is by definition, because they're a euphemism, something other than what they may have intended to convey, in which case there may be actually an ontological problem of ambiguity here that was deliberately put in. But with these special cases to one side, I'm not going to deal with those now. Rules of interpretation generally do resolve questions of ambiguity in ascertaining original public meaning. By contrast, vague provisions, even when interpreted, that is, vague provisions, the actual wording itself, even when interpreted contextually using all the available rules of interpretation, method of interpretation, simply do not contain the information necessary to decide all matters of application. Vague terms are not wholly indeterminate, they are underdeterminate. Clear or paradigm cases of things that are light or things that are heavy, weapons, things that are weapons, things that are not weapons at all, do exist. But the problem is borderline cases. And when such cases arise, the information conveyed by the language has run out. The information contained by the language has run out. When this happens, we must therefore, in my view, engage in construction and be, somewhat forthright about this. Our restrictions, let's say, for example, our restrictions on sound trucks on a residential street an infringement on the freedom of speech or not? Now, it certainly seems like they could be. They're stopping somebody from speaking on a street. But are they infringing that right or not? How about the requirement of obtaining a parade permit before demonstrating on a public street? Why can't we all run out and now block the road because we're so unhappy about the current Supreme Court without getting a permit first? Is that an infringement on our right of peaceably assembling? Possibly. Sounds like, at first blush, like it's stopping us from doing it. The original meaning of the text, in my view, does not definitively answer these and many other similar questions of application. Instead, we handle these questions by the doctrines, for example, in this free speech area in assembly, by doctrines governing time, place, and manner regulations of speech, press, and assembly. Now, these doctrines, in my lexicon, are constitutional constructions that are nowhere in the text. You can read that text front to back, up and down, and you're not going to find a doctrine of time, place, and manner regulations in there. But they turn out, I think, to be a very good way to put into effect what the text does say, that the right of freedom of speech should not be infringed. Now, this is not to say that when the information provided by interpretation has run out, all decision rules have run out. We could adopt a decision rule that where a term is vague, it's given its narrow meaning, its narrowest meaning, let's say. Or in constitutional cases, we could say that legislatures have a free choice in borderline cases that cannot be second-guessed or ought not be second-guessed by judges. But these are these rules of decision I would call rules of construction, not rules of interpretation. They are not actually providing meaning to the text. They are saying, what do you do when the meaning has run out?